Welcome to Probate Weekly. I'm Bill Gross at Bill Gross Probate on social media, and we get together every Thursday morning, 9 o'clock live on the Zoom call if you want to register. And most of the time, we interview leading attorneys and experts in the field of probate real estate across the country. Really excited to have today really one of the real experts, as well as one of those generous, I think, resources of information in probate law in Southern California, Jen Sawday of TLD Law. She's a second-time guest. Jen, thank you so much for coming back today.
Yeah, thank you for having me. I'm glad to be back. There's a lot to talk about. So let
Well,
me
there's
know when you're
always a lot to talk
ready.
about with you. I always feel like I could just wind the ball up and throw it and we can play. But today, we don't want to go into detail on this because it's so new. But there's a law that I saw the article that you wrote in the Daily Journal about this new law, AB 2016, that purports to solve the problem, and using air quotes for those who are listening, solve the problem as if you could, of probates, making that simpler as if you could or not. And yet, when I read that, I thought of all kinds of problems. And so I read your article. You identify some major issues that haven't been worked out yet. What is the prospects of this new law in the state of California? What's it going to look like, do you think, or where are we at right now?
Well, in California, we have two procedures to transfer real estate of small value. One, if it's under 55,000, we can have the next of kin sign an affidavit, send it to the court clerk, and it'll transfer the land to the next of kin. It works well when you have land in Bakersfield, Kern County, small parcels worth 5 to 10,000 that never wound up in a trust, or we forgot to probate it. That's easy. It's one and done. And then there's another procedure where you could do a petition, get it set for hearing one, and then again is one and done. But that number was 166,000, increased to 184. And the new law that you just talked about is going to increase the number from 166 to 184 to, get this, $750,000. So if you own a home in California worth less than 750,000, that's a huge jump. You may be able not to use probate, not have your property in a trust, and instead rely on this special affidavit procedure. It's going to be effective on April 1st, 2025. It passed the California State Legislature this past September. And now we're starting to say, oh shit, what's going to happen? We don't know. I haven't seen the forms yet. I don't know what boxes are going to be checked. I don't know how the clerks are going to use it. I have 3 or 4 big problems with it. Number one, there's still not a house in California.
Hold on just one second. Let me pull a color on this. So here we have one of the leading probate attorneys in California, my way, and she's saying she doesn't understand how it's going to work. Imagine the clerks in each individual county, they're not going to necessarily know where she's at. Not to mention, you can have the attorney and do the paperwork and have the county sign it, and you have to take it to a title company who has to acknowledge that they're not yet prepared. So as Jen says, she's not clear on this. Nobody's clear on this, and she's going to identify the potential problems. I'm sorry, Jen, go ahead.
Yeah, no, go ahead. So at 750,000, that still doesn't cover most properties in LA and Orange County these days. It just doesn't. So the number's already out of date. So keep that in mind. Number two, when you fill out the form and you send it in, it vests the ownership of the property into the name of all of the people that are on title. So if mom and dad die with a home in LA County worth 500,000, say it's a condo somewhere, and they have 7 kids, all 7 kids are going to immediately come on title. 7. And if one of them passes away, you're going to be back in a probate. Or if all 7 don't agree, you don't have a decision maker or a point person to sell the property. And when you do this, title company may say, I don't understand it. I don't like it. I'm not going to underwrite it. And lastly, when you do all this, you still don't have power to administer a dead person's estate. You need powers either to be trustee or in a probate, to forward mail, to file tax returns, to deal with creditors, and to turn in that iPhone. I'm telling you, just because we have a little outlet here to make it easier, we've made it worse.
Yeah. And I think, and any who follow, I have a separate podcast to do, a real estate market update every Mondays. And the basic theme is that the news is not effectively teaching us what's going on in the marketplace. One of the common themes is that the government keeps passing legislation to solve problems and they make it worse, whether it be rent control, housing affordability issues. And this is another case where at least at first glance, and again, here we're talking one of the leading attorneys in our area saying she's got major concerns over what can happen. And for the rest of us, it's certainly not an easy solution as it sits today. And it seems if the government gets involved, things get more difficult. So thanks for the high level overview. Can I share the link to the article that you wrote? Would that be okay with you?
Yes,
Yeah.
you can share the link.
Daily
You can
Journal.
do
I'm
that,
going to put it in the chat box if you're on the Zoom call, and then we'll put in the description on the YouTube if you watch the follow up on that as well. So okay, so I think the goal of this was, and I think we're going to have you back. We talked about maybe in January, February, or sometime before April, where hopefully by that time maybe there's clarity, maybe there's more forms, maybe there's something issued by the Secretary of State or somebody, whoever is appropriate for that. So we'll have you back before this goes into effect, so we can hopefully.
As soon as the forms are released, the Judicial Council form, and then it has on the back the instructions that I post it, bring me back and we can pick it apart.
Fantastic. Thanks so much. So the topic today, really, this is just something that just came out because you just wrote the article. I think last week it came out and I saw it. And so one of the things I want to just kind of start with is, of all the attorneys that I've worked with, you're one of the most active on sharing information like this article, not just writing articles, but on LinkedIn in particular. And I would urge anybody who wants to learn about particularly California's probate, but just I think in general, how attorneys think and how they look at things, to check out your LinkedIn profile, because you're very active as far as posting content as well as sharing content. So talk a little bit about why you do that and what that does for you and how that helps you with your clients.
Well, I have a lot of clients. We have a lot of probate paralegals here at the firm. We have about 5 girls that handle probate. I share because it's my style to be as informative as possible. I don't need to give legal advice, but I can talk about things and share. I want to share there's an awareness of probate, how it works, and if you wind up in it. But I also want to share to avoid it. So I don't know if you remember this, but when I was 21, my mom had died from cancer. She was 46. And then a couple years later, my father had a heart attack and he died. He was 54. I'm going to be 52 this year. And I had to go through probate. And I hired a probate attorney back in 2001 because my dad died before 9/11. I used to have to drive to his office every week. We didn't have, email back then. We didn't have chat. We didn't have. And I sat in his office and I went through the probate. And I wasn't a lawyer yet. And I paid about $16,000 in an attorney fee. So my job is to educate and share. And if you wind up in probate, let a good attorney help you. But let's avoid it. Let's set up a trust first. But I've got a big rant. I can't wait to share it. So let me know when you're ready.
You have a big what?
Rant.
Ran away. Jen's rants. If you haven't followed her on LinkedIn, you've missed Jen's rants, and that's why I love her. And I saw one rants and I jumped in on it. We had a discussion, and then she agreed to come on the show. So go ahead, ran away.
So in LinkedIn and in my practice, my clients come and I set up trust and they're happy. Almost all of my probates are brought to me by a real estate agent. All of the listeners out there, everyone watching the podcast, everyone out there. They're trying to grab the probate listings. I get it. I want to grab them too. I want the probate. But when you call me or you email me at 5 o'clock and you say, I have an emergency. No, there's no emergency in probate land. The court's open at 5. The client's dead. There's nothing we can do. But when I respond to you and I say, yes, I'll call you first thing tomorrow morning, I'll send you an email, and I task someone else in my office to do it, my paralegal or another attorney, to jump on the phone and explain, they're part of my team, and you say to them, I'm not going to talk to that person. I can only talk to Jennifer. Why? I'm like the doctor. You don't want to talk to my nurse? Why won't you talk to my paralegal? They know about probate. They can explain it to you. They can talk about the process. They can bring you into the firm, screen the case, see if there's something going on, and then we can schedule the appointment. So now I have to call the lady back or the gentleman back and say, gosh, why wouldn't you talk to my paralegal? What's going on? Oh, your aunt died 5 years ago? Oh, what's the title of the property? Oh, do you have a death certificate? Why do I have to do that work? Why won't you talk to my team?
In a law firm, anybody who's ever gotten a bill, usually have a different than probate where there's maybe more flat fee. But when you hire somebody like as a company, and they'll say, okay, the senior partner bill's at, whatever the number is, $1,000, $700, and then the associate, at this rate less, and then the paralegal less, and then, lower rate for copying costs and such. And so obviously what you're doing is keeping the cost down by having number one, the lower level employee who can do the job competently handle it. And two, no disrespect to Jim, but my guess is the paralegal is much better on the basic information, the basic checklist of what has to come in. And so I try to set it up by sending an email with all the pertinent information to the attorney. You can just send that to the paralegal, and I'll attach the public records, any documents we have and things like that, because the less time they spend, the less, the more likely they are to want to make the phone call and help out. So really, real estate agents will tell you they don't want to talk to your paralegal. They want to talk to you only. That's like, that's unbelievable. Again, I used to work my father was an attorney, so I understand how the law firms work. And the reality is, if you sit in the firm, you think the paralegals do all the work. It's kind of true in terms of the paperwork and the administrative stuff. But okay, so rant number one is real estate agents not wanting to talk to the paralegal, but wanting to talk to you only. Okay, got that one.
Yeah. And they have to pull title. We need the death certificates. We need information. They will help you. They can spend an hour on the phone, take their time. And I point to the paralegal that will help you the best. I've got girls that speak Spanish. I have girls that speak Korean. We can pull in the right person. And I'm in charge. I'm still the architect. I'm still figuring out. You'll still get FaceTime with me. I'll still be part of the meeting, okay? That's rant number one. The second one is you cannot spend the money from when you sell the house in probate. The money has to go into a bank account. It cannot be used to relocate the person that's living in the property. Just because mom and dad died and the adult kids are living there, and we have a reverse mortgage and they have nowhere to go, and they need 10,000 to move. We cannot release funds. I am an officer of the court. I've been sworn by the state bar. The money is going into an estate account. It's going to stay there until probate closes. We can sell property right away when it gets open, but probate has to remain open for 4 months. So if we sell in there and then we get ready to close, we are not writing any beneficiaries any check for any reason at all. And if you don't understand that as a realtor and you keep calling me, you don't understand, Jennifer, you don't understand. No, the answer is I've been doing this for 20 years. You don't understand. So how about you listen to me and I will tell you how it goes. So when I talk to my clients, I don't talk this way in the meeting. We bring them in and we can cry together and we can explain it. You've got to trust me. I am not here to mislead you.
So just to walk through a little bit of what the procedure looks like. So when the probate's opened and there's a house that's sold, the money goes into the account of the estate. And then at some point you prepare a final accounting, and then you have to file that with the court and get a hearing date. And the court has to review that and agree. And sometimes it's back and forth on paperwork and requests and requirements and such. If it doesn't get delayed, the court at that hearing may approve it. Then you can begin the process of writing checks at that time. And that court date is what, like 30 days after you file the accounting. So you prepare the accounting, file the accounting, hope the hearing goes well. So you're talking really minimum, probably a couple months after the sale of the house before the money gets distributed.
Yeah. If you sell the house at the minute probate's open, I can't even file a final petition until 120 days. I tried once to file it early, back when I was younger, knowing that my hearing date would be after the 120 days, and I got admonished by the judge. The judge said, Ms. Sawday, never do this again. You file it after the 120 days. So I've got 4 months. Then I file. In Orange County, those filings that I'm filing now are being suspended because they're short 17 people in the clerk's office. So I'm not even getting a response to my filings for about 4 months. Then when I get the hearing date, if it's a fast track, I'll get it in 30 days or it'll be another 4 months. In LA County, I'll get it filed and get a hearing date in about a week, but it'll be 3 months away. So right now it's November. So my final petition filings right now are January and February. Depends
That's
on
if, just to clarify though, that's if the escrow closes, and then you get the closing statement with the funds you deposit in the estate account. Then you begin to prepare the filing, which could take a couple of days minimum, and you file it, and the date you get in LA is only 3 months out. And I've had cases many times where, I'm sure you did too, you probably do a better job, where in my case, the attorney makes a mistake at that hearing date, and then you follow the notes, you try to get the attorney to fix it, try to get them to fix it, and they don't, and then the judge continues you for 90 days or 6 months. I have one that's closing hopefully next week. Our continuation was 6 months in San Diego County. So rather than closing in May, we're approved for the recommended approval. So I think we're done. 6 months we're waiting to distribute the money, right?
Yeah, but a lot of it is not usually attorney mistakes.
This
We
was.
do the same
This
thing
was.
over and over again. What we're seeing in LA County is they've hired new examiners and clerks. So they have different ways. So we don't know them. So when I prepare the pleading, I repeat what I've done and what worked. But now if I have a new hire in that department and the judge wants to change the procedure, or I have a new judicial officer, I go, uh-oh, I didn't understand they want it this way. So sometimes hearings get continued one, which is okay. But guess what happened? All my hearings on November 1st were continued. Why were they continued on November 1st?
The Dodgers won the World Series.
Right?
Every hearing was delayed.
So
For how long?
I had a probate closing on November 1st.
Yeah, people don't understand that. Every probate LA County hearing on the day after Halloween was a Friday when they had the parade downtown. They closed the streets. You know, well, what's the big deal? Well, the court said, well, if they close the streets, people can't get here. You can't blame people for not showing or showing on time. So we'll just close the court and just delay everything 3 months.
Yeah, and in the LA Times, if you go back to the website, it shows that it was right down Hill Street. It was just
Right.
mobs of people, which was great, but not good if you had a probate. My point is that we can avoid this, right? We can set up a trust. A trust will avoid almost all of this. You will pay $900 instead of $29,000. It's so much better.
Well, let's hold on to trust. Let's hold on to trust part.
Probate, I will help you. I will keep you to the listing. I will do a good job. We will have a team. We will make it work. We will all get paid. Everyone will be happy and the clients will get good service. But I can't do it on a rush because there isn't a rush. And you have to trust me when I set expectations with the timeline. And you have to talk to my paralegals. Now, we do have a rule. If you're rude to staff when you call, too bad. I'm not going to help you. We have so many cases. I need you to be nice. You can send me an email. But if I say Stephanie's going to call you back and Stephanie calls you within the hour and you say, I don't want to talk to Stephanie, we've got a problem.
Well, I'm not trying to talk to Stephanie. Anyhow, I mean, unless that's something that requires your judgment, if you're talking about just work and the paperwork, I know you're not going to do it anyhow. All you could do is take notes and send to Stephanie. So to me, that's just the right way. Let's not go into the estate planning yet. Let's stay on the rant on probate. The other thing that people understand is that you file a document and the court reviews it before your hearing date, but oftentimes they may only review it 7 to 10 days beforehand. You find these new procedures or a new change, or the clerk doesn't really understand what you're doing, and they create what are called probate notes, things that you need to fix or amend or explain. But you have like a day to get your paperwork done, and then you refile, and it may or may not get to the judge before the hearing date, which may or may not mean you get delayed again. Now, I know you guys are very diligent. I work all the time with attorneys who don't understand the urgency of that, because the court will say, it takes 3 days for something to get filed to get to my desk, and they only give you 4 days. Well, if the attorney takes 2 or 3 days to prepare the document, you've missed your opportunity. So talk a little bit about the urgency of that with it, maybe it's not something you're involved with. Maybe it's your staff that does this.
There's a couple of different approaches to filing a petition to close a probate. I had a probate that was open for 40 years. And that woman had gone through multiple attorneys. And so I was the last one. And she had said to me, every attorney that she worked on before died. So I got worried that I was going to die in the probate. But it had been open since 1976. So in that case, I filed the final petition to close because we finally sold out the property. I did not know what the court would want and what would stick. So in that case, I filed what I thought would be the best and reacted to the notes, because I didn't know what the court would do. That's why I chose that on purpose, and I warned the client and make it continue multiple times so we can address the notes. The court hires what we call probate examiners. They're either clerks, retired judges, or they're actual attorneys that work for the county courts, and they are supported by the different judges in the different departments. The examiners, we get to know them, and they have different examiners for different kinds of matters. So once I know what my examiner is going to be assigned, they post notes. If the examiner has worked with me before, I can probably clear it and get it done a couple days before the hearing, or say at the hearing, I've cleared my notes, Your Honor, your examiner has it, and it'll get approved. I don't usually operate that way by just filing something, see what sticks, and then clearing. But we have to do it sometimes The cases are too complicated. We don't understand what the courts are looking for, or the file's just a hot mess. We do it on purpose. Most cases we don't. We file exactly what the court wants and we send it in. Sometimes we overlook things or the examiner doesn't understand what we filed. Sometimes we ask for a large reserve. If I sell property here and I know the property is going to be reassessed, and in LA County, the reassessment takes 3 to 4 years for it to come in, I have to hold back a high reserve for the property taxes. It might be $25,000. So the examiner says to me, why is the reserve so high? What's 25,000? And I write back, no, you don't understand. And they go, it still doesn't make sense. They don't understand because they're new. Another note that I often get is that I can only deposit $250,000 per bank account. And so the examiner says, well, have you done this? Well, many of our banks that work with fiduciaries have what we call CEDARs or ICARIUS. They have plans where you can put all the money in one account, and then they open up sub-CDs. And some examiners don't understand that I've met the FDIC insurance requirement. Now I'm educating them. But we're always nice to the courts. We're always nice to the clerks. We're nice to the examiners. So I usually tell the client, the hearing will probably be approved, but it may not. It should get continued one. But I can come in and solve quite a bit. But again, like with November 1st, I had no clue.
Yeah, well, nobody did. Nobody did to the day before, I think, when, well, first the Dodgers won the World Series like on Tuesday night. So Wednesday morning, they're planning a parade and they decide it's gonna be Friday. And then that trickles down to a map and that trickles on the court. And so I think it was late Friday or late Wednesday that they announced this.
The case that I have, I give you detailed advice. I tell you in your case what I expect to happen. If it's just a sole hair or 2 kids, the accounting is going to be waived. We can fast track quite a bit, but it requires cooperation. And listen, I'm happy to explain. I'm happy to repeat. I'm happy to have meetings. But you've got to trust us. And now that's what I can't stand is when the agents undermine me. Oh, well, you don't understand. I said, wait a minute, we've talked about this. I understand that your client needs a home, but we cannot distribute funds. We can get creative. I mean, the agent can cut their commission and give the client a cash back and do that. Do they want to do that? No, but they want me to break the law by giving money sooner. And you want good people. You want me to do everything by the book.
Do you ever work with probate advance companies to advance money when a customer needs some distribution?
I do. I don't. Yeah, I do. That's a tough one.
That's a tough one because it's expensive, but sometimes they need it. And so it's a fine line. And you're dealing with people almost by definition who haven't been responsible up until that point financially. And now you're charging them you charge them a lot of money to get their own money. And yet, they may need it for their life. I do a lot of them, but they're one of those things where you always have mixed feelings about that, I think. And attorneys always, I think, feel when they hear we've done in advance, always kind of look down on it. I try to explain, I'm trying to help this person, right? I'm not making that much money on it. I'm just trying to help them in some degree.
Yeah, but you have to understand that you can help yourself. You can make sure mom and dad have a will that give a cash gift. I can give away cash gift early. We can have a trust. I mean, there's a lot that we can do before it happens.
So let's talk about that.
The other thing is do it soon. As soon as someone passes away, do it before the reverse mortgage company finds out. Do it before you get the foreclosure notice. Do it before you get the recorded notice of default. Get ahead. Take care of it. Time will buy you grace.
There's nothing like preparation and planning to avoid problems beforehand. And I think another area that you would agree on is if mom's getting ill, it might be time to review everything. I literally met with a guy last night who his mother's having some severe challenge with cancer, and you hope she recovers, you hope she lives a long life. And her estate plan was done in 2012. And I said to him, generally we say about every 3 to 5 years with the changes of laws and procedures. And in her case, maybe there's some new laws in the medical directives, also, the Medicare exemptions and irrevocable trust. I said, you really need to consider, yes, it may cost you $5,000, in their case, more complicated, $5,000 to have a sophisticated new plan done, but you're going to save hundreds of thousands of dollars if you don't. So talk about that trade-off. I know that, like me, you talk to prospective customers or customers all the time to try to get them into action on estate planning. What's that trade-off look like from where you sit?
Estate estate planning is hard. People don't want to set up a trust because they think they're putting a timeline of when they're going to pass away. They don't see it as an active log, or they can't afford the $1,000 or the $2,000 that it's going to take to do it. And some people just don't care. You can always write a will. You know, a will doesn't avoid probate, but it makes it a lot easier. You can take your yellow pad, right? White paper, you can take your pen, do it in blue ink so that we can tell it's the original. You can write on here, it's my last will. I am married, I am not married, I have 5 kids, I have 2 kids. I named so-and-so to be my executor to serve without bond. I want everything in equal shares to my kids. I want everything to my niece. You can handwrite what you want. So you already know. You handwrite, and then what you do is you sign your name, and then you date it. And then maybe you put on the top, my will, right? My will, sign your name and date it. California says that if it's entirely in handwriting, not witnessed, not notarized, entirely handwritten, signed and dated, it's a will. You could do it. I asked my clients, when mom passes away and I check title, we don't have a trust, did you find a writing? Yesterday, I signed up a client for probate, and I got a little Ziploc baggie. It looks like this. It had a piece of paper and it was bright yellow, and I opened it and I read it, and it was a will. It waived bond. It gave everything to the favorite son. So now I'm going to take it and I'm going to lodge it with the court, and that probate will go according to the will. It's easy. Now, I don't want you to write them for mom, but you could suggest to mom, you know, when you have time, here's some paper, here's some pen. Why don't you write out a will, keep it in a safe place. After you pass, I'll find it, I'll submit it to probate, and we'll go. That's free. It's not going to avoid it, but it will make the situation a little better.
Well, I promised to let you out of here by 9:30 because you have a staff meeting. For those who are listening, I'm so excited to get Jen, but she has a team meeting at 9:30. And so just one last question, if I can, before we let you go, and it's up to you how long you need to answer it. What's the biggest mistake, besides being rude to your paralegal or insisting on talking to you, which we talked about already? What's the biggest mistake you see real estate agents make that they can resolve to be more productive in their business?
It's telling me that they have all the information.
Mm-hmm.
First, you haven't pulled prelim. No, I'll pull it for you. I'll pull it. Second, you haven't even gathered a death certificate. You have to order them. Third, you tell me, oh, it's all going to this kid. No, I need to know the names of the entire family tree. It's failing to tell the clients that we need data.
Yeah, it's information, because even if it's all going to one child, the other ones all have to get noticed, and they have their chance to fight it. They have their chance to object. They have their chance to hire an attorney and say that that child is doing something wrong, or the will is made up or something. And so absent they're getting noticed, you can't really get anywhere with it. So look, Jen, I know I promised to get you out of here. So I really appreciate always having, for those who are watching, stay online. We'll get some other things we're going to talk about. Yeah. But I did promise to let her go. So thank you, Jen, so much as always. And then we're going to have you back after you get the new judicial forms out for the new form, maybe January or so, and we'll go into detail on the California law, okay?
Yeah, if you stand before I do, let me know, and we'll go over them together.
Fantastic. Thank you so much. Appreciate it.
Okay.
Bye-bye. For those on the call, look, I do know that, number one, you can see her on LinkedIn. She is Sawday. So it's linkedin.com/in/Sawday is the link. It's in the chat. And I'll put it in the description on the YouTube as well. So a great place to ask her questions, comment on her probate content. Second, if you follow me at all, you know that I constantly tell real estate agents that in building your business, you want to do two things. You want to learn about probate, and then you want to share what you learn with your customers. Now, Jen is an attorney here in California and a great resource, both of California procedures and also the kind of the mindset of attorneys to learn how they talk, because she's very active in the comment section. And so you can kind of learn how she talks, learn how to communicate with her. Great one to follow. But again, I would urge you to follow her on LinkedIn so that you can get content, maybe repost it to your client database. And I think it's just really important for us to have that information. So I'll put that in the chat box as well. Just real quick, for those who kind of came in late, we had Jen Sawday as our guest for the first 30 minutes or so. This is Probate Weekly. If you want to get live on the Zoom call in the future, you can register here at probateweekly.com. All we need your email address, and you're registered, and you'll get the link every week to come on live. If you scroll down, you can also get us on other audio formats or see past episodes on YouTube, and we'd love to have you do that as well. We continue the conversation. I primarily do on in Facebook under Probate Weekly. It's the name of the group, Probate Weekly. And if you go there, a couple of things that I would urge you, especially if you're a real estate agent, is you can post your content to get more likes and views and such. Let's see, these are mine, that's mine. Boy, not much content from other people these days. I guess I'm posting. Here you go, Probate Help Desk. Reen Kasolka has really built this fantastic website called Probate Help Desk as a way to generate leads in his market. He is in Minnesota, but he gets views on our website, and so love to have you guys do the same thing. Brittany Stephen also has a great website you guys should check out. Feel free to go there and participate. Our guest today earlier from TLD Law is Jennifer Sawday, who is a partner in the firm, as well as I think the head of the Trust and Estates Division. And then you can see her on LinkedIn under the name Sawday. And then I also posted in the chat box this great article if you're in California, specifically on changes are upcoming next year in April, and we'll have her back to talk about that. Okay. Any questions? We've got a nice group on today live. Any questions you guys have, put in the chat box or raise your hand, and we can continue the conversation. I do want to announce a new resource for kind of our community. I've really built my business on this podcast and then YouTube. And, I get solicited by a lot of people on YouTube. When you have a channel, they solicit you to pay the money. And what I've noticed is that so many people who, quote, build real estate agent YouTube channels, their YouTubes are way less than mine in terms of views and subscribers. And so as I built out my team, I have a team of 40 real estate agents across the country that focus on probate real estate. I'm encouraging them to use YouTube as a tool, and the same thing with all video, to build their business. And so I've announced them next week, starting on November 11th, I have a free workshop in the probate group, the Probate Weekly group in Facebook, 2:30 p.m. Pacific time, on how to use Facebook to build your business. And the idea is we're going to do this a half hour weekly. I'm going to host it, but I'm also going to have my virtual assistant, who's my YouTube channel manager, come in as well and give comments on what we do and share kind of some of our best practices. And then if we get at least 10 people on the call, I'm going to offer for free a channel review by her, where she'll offline meet with you and look at your channel and help you figure out what you need to do to improve it, make it nicer, and be more consistent. And then separate from that, anybody who's with the XP Realty, which I am, internally at 3 o'clock, right after that, we're going to do one in the XP Workplace because there we can share more information. But again, for all of you, you're all welcome to join 2:30 on Monday, 2:30 p.m. Pacific time. In the Facebook group called Probate Weekly, we're going to have a YouTube workshop designed to help real estate agents build their YouTube channels, particularly in probate. And one of the things I talk about all the time is finding good sources of content and repurposing it. And again, this article that Jen has is a perfect example of that. Okay, but as we move to wrap up here, any questions, comments, anything I can help you guys with today? Raise your hand, put a question in the chat box if you can. There'll be a link for the invite to the workshop there as well. Not seeing any hands, not seeing any questions. I guess we're up to date today. Hopefully that means we did a good job. Look forward to seeing you guys hopefully on Monday at 2:30 p.m. And if not, have a great weekend, and we'll talk next week. All the best, everybody. Thanks.